In this episode, we will be discussing how California limits raising a tenant's rent. This video is brought to you by RealSerious.com, where you can screen tenants 24 hours a day. In case you've been out of the loop, California loves to legislate for landlords, so you've really got to dot your I's and cross your T's if you own rental property in the state. And when it comes to raising the rent to offset higher taxes and the many other expenses involved in managing a unit, California has quite a few restrictions that need to be followed, according to its Tenant Protection Act of 2019. So here's what the law says about raising rent in California. During any 12-month period, a landlord may not increase the rent from its lowest amount to more than 5% plus the percentage change in the cost of living, or a total of 10%, whichever is lower. So basically, 5% is the maximum amount you can change the rent, unless you decide to add to that the percentage of change in the cost of living. So how do you determine what the cost of living is? The percentage in change applies to the Consumer Price Index, also known as the CPI, from April 1st to April 1st of the prior year, which is published by the U.S. Bureau of Labor Statistics, and that's for the region where the property is located. Their website is bls.gov, and if you happen to discover a regional index is not available for your area, then you may use the California Consumer Price Index for all urban consumers, which is provided by the Department of Industrial Relations, and their website is dir.ca.gov. Please note, if you're a landlord under local rent or price controls, you would typically follow local restrictions first, as long as they don't exceed the statewide limits. Now let's continue. The Tenant Protection Act of 2019 also restricts the number of times rent can be increased during a 12-month period to just 2 times, as long as the total amount of the 2 increases does not exceed the maximum limit we mentioned moments ago. And as one would expect with new tenancies, landlords may establish the initial rent at any amount. Now for some good news. The law does allow the following properties to be exempt from all of these restrictions when it comes to increasing the rent. Hopefully, you qualify for at least one of them. The first exemption applies to any housing that has been issued a certificate of occupancy within the previous 15 years. This appears to be an attempt to protect newer investments. The second exemption applies to residential property that is titled separately from any other dwelling, as long as it's not owned by a real estate investment trust, corporation, or an LLC with a corporation member, as long as a notice has been included in the lease stating the following. As boring as it may be, we'll read it to you. This property is not subject to the rent limits imposed by Section 1947.12 of the Civil Code, and is not subject to the just cause requirements of Section 1946.2 of the Civil Code. This property meets the requirements of Sections 1947.12 C5 and 1946.2 E7 of the Civil Code, and the owner is not any of the following. 1. A real estate investment trust, as defined by Section 856 of the Internal Revenue Code. 2. A corporation. Or 3, a limited liability company in which at least one member is a corporation. And finally, the third exemption applies to a duplex as long as the owner occupied one of the units as a principal place of residence at the very beginning of the tenancy and continues to occupy it. As we've said before, California loves to legislate for landlords. So if you're seriously considering raising the rent, we would encourage you to carefully review the Tenant Protection Act of 2019 and any changes that may have occurred, because as a landlord in the state of California, if you don't dot your I's and cross your T's, you might as well start saving up for your tenants' attorney fees. If you would like to see more videos about being an American landlord, please like and subscribe.